how you are writing down a good answer. So a good answer has different components. After reading the content, it is very important to practice answer writing, or the idea of judicial accountability, or the idea of philosophy of the constitution. So make sure again it is not standardized, as it is a UP specific examination, should lie on the basis of constitutional values, constitutional principles, and it should be very much balanced. Out of 20 questions, 6-7 questions are asked only from polity, and not including governance over here. It is your duty that again, whenever you are preparing for the examination, you need to remember all the important constitutional amendments, what changes they have done to the constitution. Good morning, everyone. Sorry for the delay. So my name is Paritosh, and again we are going to take up the previous 2-year questions of UPPCS examination of 2023 and 2024, primarily dealing with the subject of polity. So before the discussion, it is very important that again you have read all the content. Now it is up to how you are writing down a good answer. So a good answer has different components that is going to make your answer stand out among all students who are writing down the answers, right? So after reading the content, it is very important to practice answer writing, because at the end of the day, you need to understand the examiner is only going to judge you on the basis of the script of your answer sheet, not on the basis of how much you have read, how much content do you know, right? So it is very important that again, how beautifully we articulate, how beautifully we present the content what I have read in the script on the basis of the demand of the question. Clear? So every subject has a different nuanced approach to write down its answers. So as far as polity and governance is concerned, there are few parameters which has to be taken up into consideration while writing down the answers. So what are those parameters? So as it is a polity question, so again you need to understand that again you need, if there is any question which is asking about any constitutional philosophy, so in introduction, I need to briefly explain that philosophy. Let's say it is talking about the ideas of judicial activism, or the idea of judicial accountability, or the idea of philosophy of the constitution. So again, I need to discuss that basic constitutional principle in the introduction of my answer. Number one. Number two, in questions of polity and governance, again, it is required that you remember basic article numbers. Let's say if I talk about fundamental rights, so you should be aware that right to equality comes under which article number, or if I talk about right to religion, it comes under which article number. If I talk about the pardoning powers of president, it comes under which article number. So that is how you're going to make sure that with this usage of articles in your answers, it is going to substantiate or more validate your answers. Clear? Then, if in any question, let's say we are discussing anything, you can discuss about amendments, what amendments have been added to the constitution, through which amendment it has been added. Number two, you can also mention if there are any suggestions you're going to mention down in your answers, or you're going to conclude your answers. You can name few of the committees which have given their input as per the following constitution article. For example, fundamental duties. If I'm discussing on a topic of fundamental duties, I can quote Swaran Singh committee, who recommended the inclusion of fundamental rights. So that's how you are going to make sure that the examiner is getting a touch or a sense of some political articles, some amendments, some political things, or let's say political facts and figures in the answers, on the name of article numbers, on the name of Supreme Court judgments, on the name of important constitutional amendments, if only it is relevant to the answer or to the question which is being asked. Okay? Number three is specific examples. Again, as and when, as it is of course state service examination, so many times there are some topics which need explanation through examples. Let's say if I'm discussing about the whole idea of judicial activism, right? So I can quote few of the instances from UP wherein we have seen the principle or the idea of judicial activism done by the judiciary in the state of Uttar Pradesh. So make sure again it is not standardized as it is a UP specific examination. So try and make sure that again the examples which you are using is UP relevant. It is not mandatory, but it is a something which is desirable. But if there are no relevant examples from the state of UP, you can quote any other example which is substantiating or validating your points in the answer. Okay? The next is you need to maintain a balanced and examiner friendly tone. So sometimes, as these questions many times would ask upon your opinion, right? So opinion does not mean political opinion or your personal opinion. Opinion should be balanced, nuanced, and in a constructive manner, right? So let's say if I'm talking about, let's say, the critically examine the role of prime minister, so I am not going to criticize the current principles. I am going to constructively tell that what are the current provisions, how its role is expanding in the current demographic scenario, and what are the possible solutions. So again, this is something a very well nuanced answer is going to look like, wherein you're not picking up an extreme, you are not going beyond the constitutional principles. Your point of view should lie on the basis of constitutional values, constitutional principles, and it should be very much balanced. It should not be maybe completely towards or completely against, right? That's how, because you're going to be future civil servants. So in the services, you're also going to be having a balanced point of view. And again, that balanced point of view should be backed by constitutional values, constitutional principles. It should not be a personal point of view. Clear? And again, in terms of tone, the tone has always to be constructive, right? So do not use any harsh words, any negative words in the answers. Your answer's tone should, of course, be in a constructive manner. And lastly, you are going to, whenever you are ending your answer, if the question is discussing about any problem, we are going to come up with certain kind of solution, right? So that's how you're going to conclude an answers, right? So conclusion is not going to be mere repetition of the question statement, which we of course used to do in our school days. It is going to close the argument which you has established in the body part of your answer. So again, depending upon the nature of the question, conclusions are going to change. So again, in the respective questions, I am going to demarcate and show how you are going to conclude the answers on the basis of the question which has been asked. Clear? So these are the few parameters you need to take up into consideration while writing polity answers. इन चीजों को दिमाग में रखोगे, so you are going to write a very beautiful answers as far as the polity subject is concerned, because every subject requires some amount of touch of that particular subject. So that touch has to be maintained, keeping in mind all of these things which I have discussed. Clear? Now, generally speaking, for any question, this is going to the ideal approach that how you're going to write down the answers, right? So, of course, the IBC model, introduction, body, and conclusion, you're going to use in the answers. So for that, you need to maintain and make sure that the answers are well presented as well. If a question is there, if you're systematically writing down the answers following this model, it is going to make the task of examiner easier for you. So that is something you need to keep in mind. I am going to make sure that the examiner is going to find my answer very friendly to evaluate. He is not going to search where I have written the introduction, where I have addressed this part of the question. It is very systematically presented in the answer. So for that, we need to follow the IBC model: introduction, body, and conclusion. So generally for polity questions, if there is any kind of a term, for example, judicial activism, for example, fundamental rights, for example, preamble. So again, in such instances, we are going to define that particular constitutional or any definition of that particular term. If there are any relevant article numbers which you are remembering from that particular topic, you're also going to use them in introductions of your answer. So the one thumb rule which you need to apply while writing down or while deciding that what exactly to write in the introduction of answer, follow one thumb rule, because it's something which students usually struggle. Once you read a question, The problem starts where again, how should I begin the answer? What should I write in introduction of an answer? So one thumb rule which you need to apply is, whenever you read the question, ask yourself, what is the theme of the question over here? I'll take you through examples as well. So ask yourself, what is the theme of the question? So that theme which you are picking out after reading the question is the one on which you're going to write down the introduction. So introduction basically means you're going to initiate the process of introducing the topic to the examiner through a basic definition, through a basic constitutional principle, through a relevant example, right? That's how you're going to introduce an answer, so that it builds a context that how and what are you writing down in the body of your answers. Clear? So that's how you're going to do that. So it should be either a definition or an article number or any committee reference that is based on the nature of the question. Clear? Then in the body part, you need to make sure that once you are transitioning from introduction to the body, so you need to pick it out, give heading that again, what part of the question you are answering over here. Let's say if the question demands critically examine something, so again, or give some reasons for this particular phenomena, so you're going to give the heading that again, this is something which I'm going to write in the body of my answer, which is exactly demanded in the question. Sometimes questions would have one part, sometimes question would have two parts or three parts, right? So depending upon the nature of the question, you're going to divide the body into one part, two part or three part by clearly mentioning the headings. Now, a lot of confusion whether we are going to write down answers in a point format or a paragraph format. So as far as my opinion is concerned, you're going to make sure, as the questions of course are of 8 marker, which is consisting of 125 words, and there are I think 12 marker questions which is consisting of 200 marks, 200 words, right? So you're going to make sure I'm going to write down my answers in most of the cases. In fact, I'll suggest for all the answers in a point format. What is the benefit of it? In that process of writing down the answers in point format, you're going to give multiple points to the examiner from that particular topic. Number one, it is going to increase the readability of the content, whatever you're writing down the answers. It is making the task of examiner easier to understand that what all aspects have you addressed of the question in the answer. So in short, make sure you write the body in point format only. Clear? Right? And then of course, depending upon the question, you're going to use datas if let's say if you're highlighting any issue. So in order to validate that particular point, you can use some data, you can quote some data, you can use some examples. That's how you're going to substantiate relevant points in your answers depending upon the nature of the question. Towards the end, you're going to conclude an answer. So conclusion is going to give a closure to the discussion which you have begun in the body of an answer, right? So you need to close down the discussion which you have started. Make sure conclusion should not have any point which is opening up a new dimension to the answer. Clear? So you are going to close down something what you have started as a discussion in the body of an answer. If there is a problem, if there is some kind of let's say issue being discussed, in conclusion you can go with the reforms, with way forward, you can quote SDG goals depending upon the nature of the question, right? So that's the basic idea we need to follow for structuring down the answers from polity and governance perspective. Now we're going to discuss questions of last 2 years, so 2023 and 2024. So we have divided questions on broader themes in which the exam or in which the PCS is asking the questions, right? So if you look at here on the topic of constitutional philosophy, I think every year, maybe for the last 2 years, two questions are asked, right? On the topic of union government, state governments, again three and 2 topics are being asked over here. Now on the question on judiciary, again 2 topics, 2 questions and 1 question, and state specific questions. So on and all, you can understand that from polity specifically, there are on an average 6 to 7 questions asked every year, right? So that makes out of 20 questions, 6-7 questions are asked only from polity. I'm not including governance over here. I'm just including polity as a topic, right? So 6 to 7 questions straightforward from polity. So polity is basically a favorite area of subjects of students wherein they find it very interesting to read. But at the very same time, it becomes very challenging once we start to write down the answers from the topic what I have read. So that is how we are going to understand that after reading a question, how we are going to begin the answer writing process. What is something which should click in my mind, that how I am going to write down the answers to the extent it is addressing the demand of the question. So again, in today's discussion, we are going to cover up the first 7 questions of 2023, and in tomorrow's discussion, we are going to cover up the rest of the questions of 2024. So that's how we're going to start with the discussion. So the very first question here is, why is preamble called the philosophy of the Indian Constitution? So again, a very straightforward question. So all of you must have read the topic of preamble whenever you are reading the Constitution or in polity. So preamble is basically called as the philosophy of the Constitution. So the question specifically asks, sir, why are we calling preamble the philosophy of the Indian Constitution? So again, my answer should revolve around which theme? Again, let's break it down in a very simple manner. If you read the question, why is preamble called the philosophy of the Indian Constitution? Apply that thumb rule. If you thumb rule what's that, how and what should be my introduction to the answer. So what is the theme of the question over here? The theme is what? Preamble is a theme. So again, you're going to define what you understand by preamble. That is a standard definition of preamble, its essence. What does it mean? Again, there is no standard definition for preamble, right? It is up to you that how have you understood, how you are making the examiner understand that what is your understanding of preamble. That is going to be the 2-3 lines you're going to write down in introduction of your answer, because as it is an 8-marker question, we need to adhere to the word limit as well, right? So it is asking, why is preamble called the philosophy of the Indian Constitution? It is basically preamble is usually at the beginning of the, is of course in the beginning of the Constitution. So if anyone wants to understand what is there in the text of Indian Constitution, if someone's read the preamble, that is, we the people of India having solemnly resolved to constitute India, the sovereign, socialist, democratic republic, and other things, if by reading this, the person who is reading the preamble is going to get an essence that what exactly I am going to see in the Indian Constitution. So every articles, every theme which is there in different parts of the Constitution are inspired by the philosophy which is present in the Indian preamble or the Constitution preamble. So preamble basically tells you are going to see, after reading the preamble, it is going to make you clear that again what exactly you are going to see in the text of the Indian Constitution. So that is why it is called as the philosophy of the Indian Constitution. So very plainly, introduction should be around what theme? You are going to define preamble of the Constitution. There will be different ways to define the preamble of the Indian Constitution. It's completely up to you that how you're defining it, right? So no strict one way to approach to define the preamble. It is up to you how you can do that. So for example, we can mention that preamble is the preface to the Constitution, summarizing its ideals, in its aspirations. You can talk about it, it was inspired by Nehru's objective resolution of 1946. You can talk about it reflects the essence, spirit and purpose of the Indian Constitution. So again, around these 3 themes, you can write down the introduction of your answer. So again, clear? Thumb rule, theme of the question, preamble, define is a word. Again, as I discussed, if there is any constitutional term over there, you can go to define them. There is no article number of the preamble, so again, not required, right? That's how, by a simple definition of preamble, is going to give you a standard introduction to this particular answer, right? Now, if we are moving from introduction to the body of an answer, so now what was the theme of the question here? What is being asked exactly? That why are we calling preamble as the philosophy of Indian Constitution? So again, what should be my heading as a body of an answer? This is how you're going to start it. Give a very clear heading. So again, this is how the examiner is going to get a differentiation. This student has defined the preamble, it has set the context, that again, what exactly is preamble, and now the student is moving to a topic of the body of the demand of the question, that is, what exactly and why preamble is called as the philosophy of the Indian Constitution. So again, you're going to give the heading, philosophy of Indian polity as enshrined in Indian preamble. So number 1 is, preamble tells us what is the source of power to the country. So who have given this constitution to us, right? Who has written the constitution? We talk about the ideas of democracy. So again, the underlying theme of democracy, that is rule by the people, for the people, of the people. So again, technically you understand that again, British government was ruling India. In 1947, they left India. So technically, India was without any government. So now we decided that again, we need to form the government. So again, government again was decided on the basis of, wow, some people who had been there in the freedom struggle. So people of the country had decided, let's form and let's select a group of people who are going to make rules and regulations for us. Clear? So that is how we choose certain representatives, and that representatives is basically called as a state, right? So now there was chances that again the people whom we are electing or whom we are choosing to be our representatives, they might become authoritarian. So that is why a text was written. That text is basically called as a constitution, which is called as a rule book, which tells that what state can do, what state cannot do, what citizens can do, what rights do they have, and what rights they do not have. That is basically contained in the constitution. So who has written this constitution? The people of the country itself. How it is signified? That is we, the people of India. So this is telling that the source of power to the constitution is from the people itself, by the text of we, the people of India. So it shows constitutions is deriving its authority from the people itself. The rule book of the country, which is governing different aspects of the governance in the country, has a source from the people itself. So that is the idea of popular sovereignty. So again, as we as Indians have given ourselves this rule book, that is giving an essence of popular sovereignty. That is the underlying philosophy of the Indian constitution, right? Number one. Number two, it tells us if I am going to ask how exactly and what is the nature of Indian state. State is what? That we as people, we as citizens of the country have chosen our representatives, and these representatives technically are called as in the broad term as state. So what is the nature of Indian state? It is also mentioned in the Indian preamble, right? So if you look at preamble, defines India to be what? India is a sovereign country, India is a socialist country, India is a secular country, democratic country, republic country. So this is the basic core philosophy of governance in the country. If people are going to be governed, so these are the basic principles and philosophy which is going to guide the governance process of the country, right? So as it is I think 8-mark question, 125 answers, no need to define these terms. Just by merely telling that again preamble defines India as these basic parameters, it is establishing what? It is establishing the philosophy or the core philosophy of governance. Right? What is sovereignty? Sovereignty basically means India is a sovereign country. India is not going to be India is going to take decisions in an independent manner without any external influence. Right? Simple. Then we talk about the ideas of socialism. So Indian socialist model is different from Western socialism model. Indian socialism means that we are going to give every person in the country equal opportunity to earn the resources. That is an idea of Indian socialism. Then we talk about India being a secular country. Secular means what? It means we are going to respect every religion. Sarva dharma sampan. The idea of secularism is basically in India is that India is neither a religious country, India is not an irreligious country, and India is not an anti-religious country. It means what? India is not a religious country. Does government follow any particular religion of its own choice? No. Then India is not an irreligious country. Is government stopping you from practicing religion of your own choice? No. India is not an anti-religious country. It means what? Is government speaking bad about any particular religion? No. So that's a model of Indian secularism. And in fact, we have given fundamental rights of religion under Article 25-28. That is again demarcating what? This secular philosophy of the Indian Constitution. Equality of opportunity, again under Article 15-16 of the Constitution, is talking about the philosophy of Indian being a socialist state, right? Then democratic elections in the country on the grounds of free and fair elections, one person, one vote. All of these are the ideas of democracy which is there in the Indian Constitution. It defines India to be a republic, that we are not going to be having any head of the state who is a monarch, who has a hereditary maybe influence in taking up that particular position. in India, republic means that the head of the state is going to be an elected person, right? So that's how the president of the country is an elected person. He is not a monarch, right? So this is something which is defining all of these principles or these philosophy you're going to see in the different areas of the constitution. Clear? So no need to define them, just mention this basic nature of Indian state, that again it is a sovereign sociality, which is talking about the core philosophy of governance. Next is, it is also talking about the objectives of Indian constitution. So again, it means what objective does it have? The philosophy, we understand what is the objective, that Indian state is going to be, certain ideals are there. Number one, we are going to ensure justice to all people. Justice of what nature? Social, economic, and political justice. Right? So there are different articles in the constitution talking about the ideas of social justice. For example, Article 15 talks about that again, there 15 clause 3 talks about special provisions have to be made for women and children, talking about the idea of social justice, right? Then again, DPSP contains many principles which is talking about the idea of social justice, right? Economic justice, political justice, all of these. Political justice means every person have a right to vote, one person, one vote, universal adult franchisee, again, all talking about the ideas of justice. So this is something which is talking about, these are the ideals which we as Indian constitution is trying to achieve. Then the ideas of liberty of thought, expression, belief, faith, and worship. It is talking about the ideas of that again, in India, every person have a liberty of thought. They can think whatever they want to think. They have a ownership of expressing themselves. They have a right to understand and believe in whatever religion they want to believe, whatever God they want to worship. So this is something which is telling an ideal of Indian state. Then we talk about the ideas of equality of status opportunity, that every person in the country is equal, irrespective of the fact whether you are a prime minister, whether you are the president, whether you are a businessman, everyone is equal in the eyes of law. So that is talking about the ideas of equality of opportunity, that every person in the country will be given equal opportunity to earn basic resources, right? So that is how it is talking about the ideas of equal opportunity and let's say equality of status. Then fraternity, that again in India we need to have a sense of brotherhood, the sense of unity, dignity, and maintaining the integrity of the nation. The whole idea of nationalism, patriotism is again guided by these certain philosophies, right? So basically these ideals, or which is mentioned in the preambles, is reflecting what? The value framework of the constitution, that again on what values, justice, equality, liberty, fraternity, our constitutional principles are ensured, right? That is how you're going to mention point number 3. Then point number 4, it also talks about that the date of adoption, that again the constitution was adopted in the year on 26th of November 1949 as it was adopted, and it helps understand constitutional timeline and intent, right? Since when we have started to adopt the constitutional of the country. Then it is also many times understand, if I am going to write that why it is called as philosophy of the constitution, you need to understand it was debated initially that whether we are going to consider preamble as a part of the constitution or not as a part of the constitution, right? So through a series of judgments, lastly in the Keshavananda Bharati case of 1973, it was decided that preamble is a part of Indian constitution. So at any point of time, there is any kind of confusion regarding any of the interpretation of articles of the constitution, if that article is not giving a clear picture, we can refer the preamble, the philosophy of the constitution, and then interpret that particular article. So again, it is a part of the constitution. It is helping the judiciary to interpret different constitutional articles whenever there is sense of ambiguity, right? So that is telling it is an important philosophy of the constitution, that in any matter or in any situation where again we are in doubt whether what is the actual interpretation of the article numbers, because many times to understand different article numbers are contrary to each other. So in that, to clear that confusion, we are referring the preamble of the constitution as the philosophy of the constitution in terms of solving those ambiguity, right? So you can mention that as well, that it is a part of the constitution. This is how you're going to mention. Important Supreme Court judgment, Keshavananda Bharati case of 1973. So preamble is a part of constitution. It acts as a guide whenever there is any confusion with respect to interpretation of any constitutional provisions. So it holds both philosophy as well as legal significance, right? So now in conclusion, in such kind of questions, you are just going to summarize in 1 or 2 lines what you have written in the body of an answer, that how we are establishing that preamble is the philosophy of Indian Constitution in a very simple 1 and 2 lines. So you're going to mention that again, how preambles contains the visions, the ideals, the aspirations and the goals of the Indian Constitution. So functions as a philosophical compass for what? For lawmaking, for governance, for judicial interpretation, all of these things are there, right? So hence preamble is called as a philosophy of constitution. We are going to very clearly mention that again, how this philosophy of constitution is helping us to ensure that lawmaking is being done, judicial interpretation is being done, and the governance is being carried on the basis of that particular philosophy. That's how you're going to conclude down the answer, right? So no need to define all those words of sovereignty, integrity, justice, just a basic one line, and these 4 pointers, that we the people of India, number 1, number 2, the source of power, then the philosophy of the constitution through what? The sovereignties, let's say democratic, republic, socialist, secular, then the ideals of the constitution, justice, liberty, fraternity, and lastly the interpretation that it is a part of constitution. And again, whenever there is any confusion in understanding the constitution, we are going to refer the preamble of the constitution itself. That is telling us what? That preamble is the philosophy of the Indian Constitution. Clear? That's how we are going to conclude down the answers, right? Now, moving on to the next question. Why is 42nd amendment, again, straightforward, an amendment is being asked. So again, for this, it is very important that for the future, there could be questions on 44th amendment, there could be questions on, let's say, 86th amendment. So for that, it is very important that you remember important landmark constitutional amendments, right? Because it is not telling what has happened over here. It is just telling 42nd amendment and asking the question. So again, it is your duty that again, whenever you are preparing for the examination, you need to remember all the important constitutional amendments, what changes they have done to the constitution. You're also going to remember all important Supreme Court landmark judgments, how it has changed the shape of the political system working of the country, right? So important Supreme Court judgments, important important constitutional amendments, and important committees which are there from respective chapters. You're going to read them very carefully, because ये directly आपके questions बन सकते हैं. आपको ये पता होना चाहिए कि इस amendment में हुआ क्या था, right? If I talk about 86, if I talk about 97 talks about inclusion of cooperatives, right? 86, right to education, right? So that's how important constitutional amendments you should be very clear of in the process of preparing for the examination. Now, it is asking why 42nd amendment is called as the revision of Indian Constitution. So whenever you read the constitution text, 42nd amendment comes many times into picture, right? So this is why it is called, in fact, it is called as a mini constitution. So again, this is where you need to understand the demand of the question here. Is the question asking you to write down what has happened in the 42nd amendment? No. It is going to ask, or is asking you, that why we are telling this 42nd amendment as a complete revision of Indian Constitution. So again, that's how you are going to mention that how 42nd amendment made many changes to the Indian Constitution, so that it is also being called as the entire revision of Indian Constitution. That is the basic theme of the question over here, right? ये पूछ रहा है कि 42nd amendment में ऐसी क्या चीजें हुई कि इसका हम बोल दे रहे हैं कि it is just the revision, or just like we have rewritten the new constitution. That's how you're going to proceed with an answer. right? So you're going to make sure and address that again, what all changes were made in the 42nd Amendment. It just looked like it is changing the entire nature or the entire structure of Indian Constitution. That is the essence of the word revision of the Indian Constitution. So again, what is the thumb rule? Theme of the question is what? 42nd Amendment. So you're going to define in what year 42nd Amendment happened, what were the underlying reasons which led to that particular amendment, kya tha us year mein, what has happened. So that's in basic 1 or 2 lines you're going to introduce your answer, right? So in this you can mention that again it was amendment of course passed in the year 1976 during the period of emergency. Very important to mention this. This is going to give examiner an impression that yes, student is aware of the fact that this amendment happened in the period of emergency, and that is how it can interlink the fact that again why it is called as the revision of Indian Constitution. Clear? So it's called as the revision because it is of unprecedented number of changes it made, and it transformed the entire constitution, and often it is also called as the mini constitution as it altered the entire or mostly the philosophy of the constitution, structure and functioning of the government at different levels. That is why it is called as the revision of Indian Constitution. So basically you are setting up a context कि क्यों 42nd Amendment को हम बोलते हैं कि ये एक technically revision of the Constitution है. Why? Because it has made many important changes in the Constitution, maybe changing its philosophy, its structure and its the functioning of the government at different levels, and that is why it is called as the mini constitution as well. You're also giving a theme that it happened during the era of emergency. That's how you're setting up a context, that how you are going to mention that it is a revision of Indian Constitution. So again number 1 we're going to discuss what are the key reasons why do we call it as the revision of Indian Constitution, because of the n number of changes it has brought. सबसे पहले वो pointers जो लिखते हैं ना, whenever you're writing the points, write points in a systematic manner that is going to set up the context. So you are going to make sure revision के सबसे पहले क्या होगा, अगर हम बोल रहे if we are telling that again 42nd Amendment is called as the revision of Indian Constitution, so we are going to mention in the very first point कि what amount of changes it brought in, that it is itself told as the revision of Indian Constitution. So again, after writing down the introduction, we are going to clearly mention the key reasons, ye heading up denge, key reasons for calling it as the revision of Indian Constitution. Point number 1, it brought very unprecedented changes, right? It amended 59 articles. Ye numbers hai, you are going to see them. It is very important. If you're remembering them, very good, because it is going to give examiner understanding that yes, student is substantiating the points कि बोला गया कि रिवीजन है तो बता रहा है अपने आंसर्स में कि by writing down it changed 59 articles in the constitution, it added 14 new articles to the constitution, it changed the preamble of the constitution, it altered the 7th schedule of the constitution amounting to an overall, ये कोई routine amendment नहीं था. रूटीन अमेंडमेंट में क्या होता है कि एक दो चीजें चेंज होती है कॉन्स्टिट्यूशन में, बट दिस इज कॉल्ड एज अ रिवीजन. व्हाई? बिकॉज it made such number of changes in the constitution. It changed 59 articles, it added 14 articles, it amended 7th schedule, it amended the preamble, which is called as the philosophy of the constitution. So it was not just a simple change, it was changing the overhaul of the Indian constitution. That's how you have set up context in the first point. Now, the second point, again, in the preamble, we have read that there are socialist, secular, democratic, right? So, the two words, socialist, secular, and integrity were not present in the original text of the preamble. These words were added explicitly through the 42nd Amendment Act of 1976, right? So, number 1, it is amending the preamble we call as the philosophy of the constitution. If you are changing the philosophy of the constitution, you are changing the entire essence of the preamble of the constitution. That is how it is also called as a revision, because it changed the philosophy of the constitution, right? So it added the words socialist, secular and integrity, right? And it made explicit laws. I also tell what is the constitutional philosophy. Sometimes we need to understand there are, in chapter 3 we have fundamental rights, in chapter 4 we have DPSPs. So many times what are rights? Rights are negative obligations on the state. That is, if government is going to make any rules, any regulations, it should not at any case violate the fundamental rights of the citizens. Now again we have DPSPs. These are directives which are being given to the government, that state or the government, whenever you are making any policy, you need to keep these directives in mind, right? So the DPSPs were not enforceable, right? You cannot go to if, let's say, if I am a citizen, if my fundamental right is violated, I can directly approach Supreme Court, ki sir, this right of me is being violated. Supreme Court will provide me necessary justice. But if there is a DPSP which says equal pay for equal work, I cannot go to the Supreme Court and tell, ki sir, this DPSP of mine is violated. So again, DPSPs are not negative obligations on the state, number one. DPSPs are just guidelines ki state, whenever you're making policies, please consider these guidelines, what we have written in the DPSP chapter number 4. But in this 42nd amendment, what the government did was, it made that any law, let's say if I have made a law and that law is violating the fundamental right, so that law will be declared as null and void, right? Now, but in case of DPSP, as they were not enforceable, so state can make any law, as of now as well, ki it can violate the DPSP. But in this amendment, what the government did was ki if any DPSP is if any law which is trying to implement any DPSP could not be challenged on the ground that it is violating fundamental rights. That is an idea. For example, if I am implementing, let's say, any DPSP of equal pay for equal work, and in that implementation of DPSP, if I'm violating any fundamental right, so which will prevail over the other? Fundamental rights will prevail over DPSPs. That is a current understanding. But again, in this amendment, it was told कि if any DPSP is being implemented through a law, and if that law is even violating any fundamental right, that law will not be declared as null and void. So again, it gave supremacy of DPSP over the fundamental rights of citizens. So again, it gave the government more power, that government is more powerful to make any law which is even violating the fundamental rights, right? That is something which was being done over there. So again, it raised the directive principles above fundamental rights and shifting from what? Ki individual liberty nahi hai, right? It is going to be a state-led welfare. State will decide by making laws that again what is right and what is wrong for me, even if that law will violate my basic fundamental rights. That's how the second point, that it shifted the constitutional philosophy. Number one, how it gave supremacy to the idea of India being a welfare state over the idea of fundamental rights of citizens. It changed the basic philosophy by adding the words socialist, secular, integrity to the preamble. That's how it is changing the constitutional philosophy. The next point is, it curtailed the power of judiciary. You understand, it happened during the emergency situation in 1970, early 71 or 72. The Allahabad High Court contested the election process of the at that point of time of the Madam President, right? So now the government in through this amendment tried to curtail the powers of judiciary itself, right? That's how you're going to see that, and that is where we have a very clear principle in the constitution that again we are going to make sure judiciary is independent, judiciary is integrated. But again, the whole idea of independence of judiciary was curtailed. The judicial powers were curtailed through sorry, the judicial powers were curtailed through this judgment. So under this, Supreme Court ने बोला again, you understand, all of you must be knowing the idea of judicial review. Judicial reviews means it is the power of judiciary to review any act and policy of the government if that act and policy is abiding by the constitutional principles. That is the idea of judicial review, and judicial review now is a part of basic structure of the constitution, basic structure. Now, in this amendment, what the government did was, it talked about if we are amending the constitution, that is Constitutional Amendment Act, it is also going to be a law, right? Any changes which are made to the constitution, because 42nd amendment was also a change to the constitution. Ab judiciary was power thi, it can change or it can challenge that 42nd amendment also, right? But what it did was, it also added this principle that again the constitutional amendment acts are beyond judicial review. So it completely took out judiciary from the overview of correcting any law or contesting any law on the grounds of it being violative to the Indian Constitution. So again, एक judiciary major change आया, क्या किया उन्होंने? They limited the power of judicial review by stating that constitutional amendments would not be questioned in any court. And technically, judiciary had many powers, administrative powers. It established tribunals. Tribunals क्या किया? It added Article 323A, 323B to establish administrative tribunals to restrict the judiciary's role in such matter. For example, any person who is there in the service, if his service is in question, right, he is going to go to judiciary is going to give his judgment, right? But now again, as Madam Indira Gandhi's let's say election was in question, so it led, that is the major reason why such changes were made in the judiciary itself. Of course, these were corrected in the 44th Amendment Act of 1978, but here they created tribunals for any administrative matters. You need not to go to courts. We have specialized body, the tribunals, which are going to take up such cases into consideration, right? So it basically weakened the whole idea of judicial independence, which is a core philosophy or a core essence of the Indian Constitution. Clear? The next is centralizing tendency of powers, right? Many times you understand कि we have government functioning at initially till 1970s, of course, before the coming up of Panchayati Raj institutions and municipalities, we had the government functioning at two levels. One is at central level, union level, and second is at state level. And these powers that which government is having its authority on which matters of governance was clearly mentioned in Schedule 7 of the Constitution under three lists: union list, then we had state list, and then we had concurrent list. So union list contains all matters on which union government can make a law. State list contains a lot of subjects on which state government can make a law. But इन्होंने क्या किया इस amendment में? They took some matters from state list and added either them to the union list or to the concurrent list. Concurrent list में है कि both the union and state can make a law, but union law prevail over a state law in case both of them have made a law on that particular subject. Clear? So what it did was, in this amendment, few important subjects were transferred from state list to either union list or concurrent list. What is the tendency over here? It is giving central government more power over the state government vis-a-vis, right? So that is something over here. Then they also led to all of you to understand article number 356, that is imposition of president's rule, that if the state government is not in a position to handle the administration of that particular state, the governor of state is going to inform the central government that again now it's time to impose president's rule. That is the basic idea. So now the emergency provisions were also changed. Again, it was also added that again the president's rule can be imposed on the grounds wherein the governor would inform the president of the country. Now, technically you understand, governor is appointed by the central government. So he is technically called as the agent of center in the states. That's how the dilution was also led. And again, the whole idea of India being a federal country was getting changed to a centralized or a central government through this amendment. That is how we are going to see. Then executive dominance. Executive dominance means the term of Lok Sabha was changed from 5 years to 6 years. right? The government, which was initially supposed to happen, because this is a core essence of the constitution, and again the government is going to change every 5 years, but the term of government was increased from 5 years to 6 years. Now president, while imposition of emergency, president is bound, was in this amendment, it was bound that again he is not going to question. What is the idea? Of course, I'll explain. Let's say if I am council of ministers, if I am sending a piece of advice to the president, president has an option now, which was added of course after 44th amendment when this thing was corrected, that again he can send back the recommendation once, that again please check council of ministers that again whether you have what suggestions you have sent, it is correct or incorrect. It is again sending a message in the to the public that again there is some kind of incorrectness in that particular decision which is being sent by council of ministers. That's why the president has sent back the recommendation, right? But in this amendment it was made clear that president is bound by the advice of council of ministers. He does not have an option to send back the decision for reconsideration. So technically imposition of executive power was completely there under this particular mechanism, that again tilting the balance towards the executive, because you have three organs of government: executive, legislature and judiciary. Everyone has their own powers, and we have maintained checks and balances as well. But again this thing was making sure, or which made sure that again of course judiciary powers were curtailed, executive powers were made more powerful, the term of Lok Sabha was increased. That's how the entire functioning of the government was being changed, right? Now they also introduced what we call as fundamental duties, which were added to the constitution under this particular article, right? So it made sure, because as it was a point of era of emergency, so again it made sure that as citizens we are also obligated to perform certain duties towards the state. So again this is something which was correct, not, and that is something which is being cherished as well, because it is of course right, if the constitution is giving a certain amount of rights, we are also going to enjoy, we are also going to perform certain kind of duties towards the state, right, or the country. So it was right, but again it came at a point which was again a controversial era, right? So again this is how the entire, because initially there was no duties in the constitution, now it was added through 42nd amendment. So again this was something which is going to change the entire functioning and entire constitution itself. So again why it is called as revision, just one line mein likhiye is baat ko, just summarize it, that again because it altered fundamentally the constitutional basic philosophy, preamble ko change kar diya, federal balance what we have seen, rights framework, DPSPs were more powerful than fundamental rights, institutional checks and balances, judiciary curtail कर गया, executive को बड़ा बना दिया, right? Going beyond amendment, ये कोई amendment नहीं था, it was just a systematic redesign of the entire constitution. That is why it is called as a revision. So ये आपको लिखना बहुत जरूरी है. We have mentioned here by different points कि what kind of changes which were made. That is why it is called as, on these parameters, it is considered not just an amendment, but an entire revision of the Indian Constitution, right? So in conclusion, you can mention very briefly that why 42nd, ये conclusion का ही part है, that again the 42nd amendment is called as revision because it reshaped the constitution scheme so comprehensively it is resembling that now we have just rewritten the constitution. तभी इसको ये भी बोला गया है. It has been also given a title that it is called as what we call as mini constitution. एक नया constitution ही आपने लिख दिया, right? That's how you're going to explain them. आपको amendments पे ज़्यादा focus नहीं करना है, but again you're going to explain them that again how it changed the nature of Indian Constitution through the examples what we have discussed. Clear? So question को समझना जरूरी है. सिर्फ 42nd amendment आ गया इसका मतलब ये नहीं कि आप amendments लिखेंगे. आपको explain करना है कि why and what kind of changes it has brought, which is changing, which is amounting to a change in the philosophy of the Constitution, the way in which Constitution is interpreted, the way in which the balance of power is getting demarcated or diluted. All of these things have to be written down in an answer. Clear? Again, I am reinforcing the fact, Please remember and please make a list of all important constitutional amendments, all important Supreme Court judgments, all important committee recommendations. That is how you're going to use them in your answer writing process. Clear? Now, the next question. How the governor's power to pardon differs from the president's power under Article 72. I think this question, the theme of this question was also there in this year's UPSC question paper of mains, wherein it was asked to compare the pardoning powers of Indian president vis-a-vis the US president, because US president was in news this year, January. He got elected, Donald Trump. So now it is asking to compare the pardoning powers of governor vis-a-vis the president of India. Very simple. We understand the president is the head of the state at union level. Similarly, at the state government, we have head which is called as the governor. And both of them have parallel powers. But again, governor has more discretionary powers as compared to the president. But we are going to compare which power? The pardoning powers of the president and governor, right? So the theme of the question here is, how is the governor's power to pardon differs from the president's power under Article 72. So question में लिख दे Article 72 क्या बोलता है? President's power of pardoning. So what is the president's governor's article number? That is something you need to remember. So Article 161 talks about that again, which talks about that how and what are the pardoning powers of governor of the state. So what is the theme of the question over here? Theme क्या है question का? The pardoning power. So in introduction, you can mention what and why there is a need, and of course you can define the essence and the role of pardoning powers in the democratic functioning of the country, right? Because technically judiciary के पास power है ना. Judiciary is a final authority to give judgments on the basis of hearing cases. But sometimes judiciary gives some kind of punishment which is sometimes very harsh. So उस एक level पे एक correctness लाने के लिए we have added this thing to the constitution that again the president and the governors have a power to maybe sometimes whenever the punishment is very harsh, at least they have a scope of revision, right? Just to maintain a checks and balances. Clear? So you can mention that as well, that again the clemency, or we call as the pardoning powers in India, is basically to correct any judicial errors, right? To reduce undue harshness if any harsh punishment have been given to a particular person and he is demanding that the punishment has to be reduced, there has to be some scope, and that is where powers have been given to both governors at state and president at the union level, and uphold the whole idea of humanitarian considerations, right? So there is something humanity as well, right? So Article 72 बताता है pardoning powers of president. Article 161 talks about the pardoning powers of governors. ये दोनों को बिल्कुल लिखना articles number. That is why I mentioned in introduction you can use article numbers in introductions of your answers. That is going to build up a context, right? So though both can grant powers of pardon, reprieve, respite, remission, suspension and commutation, the scope of application differs significantly. थोड़ा differences है with respect to the pardoning powers of president and let's say governor, right? So again, you are just going to mention the differences. Clear? So but before this, I'd like to explain you what is the meaning of commutation. Commutation basically means that you are changing a stricter form of punishment to a less stricter form of punishment. For example, the death penalty is going to be reduced to life imprisonment. That is the basic idea of commutation, right? Then we have reprieve. Pardon means entirely pardoning the sentence, whether what kind of, let's say if I have a sentence for 10 years jail or maybe death penalty, my entire sentence is pardoned. That is completely forgiving me. Then we have reprieve. Reprieve means, let's say if I have been given a punishment of, let's say, death penalty on, let's say, this particular date, so a temporary hold on that particular punishment is talked as reprieve. Then respite basically means that again on basic certain special circumstances, let's say if there's a pregnant woman in the jail, so of course the stricter form of punishment can be reduced to a less stricter form based on that special consideration. Remission means again, let's say not changing the nature of punishment which was there in commutation. Commutation में क्या था कि changing the stricter nature of punishment to a less stricter nature. Remission means changing the duration, not the nature of punishment. For example, 10 years of imprisonment can be reduced to 5 years, 6 years, 7 years. So reducing the term of the punishment. So this is the basic understanding. So explain nahi karna, just for your basic understanding, explain this. So now after giving this in the introduction of your answer, you're directly going to give the heading. What is the heading, sir? Comparison of president's power and governor power. You have two options. Either you can make a table like this. You can mention the president's pardoning power under Article 72 and compare it with the governor under Article 161, or you can mention like this. So again, it is completely up to you, right? So a question paper mein, ek answer booklet mein, you have to apply different presentation skills. Clear? Either you can give an heading that again on what basis you are comparing, and again you are comparing with president and governor like this, or you can make a table and clearly differentiate that. It's completely up to you, right? So number one, on comparison with respect to the jurisdiction, कि pardoning powers तो है, but on what kind, on what punishments, on what laws the president have the pardoning powers and the governor has the pardoning powers, right? So of course understand that again the central laws होते हैं, union laws होते हैं, which are made by union government. There are state government, state list पर subjects होती है, उसमें कौन law बनाता है? The respective state government. So the president has a power for pardoning, for punishments, right, on any matter against or any against any which अगर एक central law के against किसी ने कोई commit किया है crime, then president has a power to pardon that particular individual. So it is exercising pardoning powers of any person who is convicted against a central law or a union law. Clear? Right? For example, any offense under IPC, अब तो BNSS हो गया है, narcotics, UAPA, IT Acts, all of these are central laws. So in every law has a punishment. For example, recently we have this whole what do we call as Online Gaming Act आया हुआ है, right? So again, it is again a central law. So in that matter, if any person is any company is found to be playing maybe promoting any online financial games, so again he is going to be punished under central law. And again, if he wants to go for pardon, he is going to appeal to the president, not to the governor. So again, president has a power to provide pardoning powers against any convictions against a central law, right? Governor, on the other hand, Article 361, he has a power for offenses committed against the state law. Clear? Very simple definition hai ki president again head of the government at union level, so again he can exercise pardoning powers against central law, conviction against central law, and yeah, against the state law. For example, offenses under state excise laws, state police acts, right? A basic example with respect to jurisdiction, किसके पास कौन सी powers है. Then the second is again, of course, it establishes a clear federal division of pardoning powers. Clear कि central laws पे president has a power and state laws पे governor has a power under Article 161. Then death sentence, very important कि in India only president has a exclusive power to pardon the death sentence, which is not available to the governor. Very important difference with respect to pardoning powers of president and the governor. So president has the only power to pardon death sentence, even if, let's say, I have committed a crime against state law, right? And for that crime, I have been given death penalty. So governor has no power to pardon that death sentence, even if it is against a state law. Only president has a power to give or pardon a death sentence, right? So president has an exclusive power to pardon death sentence. Again, he can reprieve, respite, जो भी suspend, जो हमने discuss किया था कि changing the nature, changing the duration, all such things, or commute that penalty, right? Even if conviction is under a state law, only president can pardon death sentence. Cannot pardon, governor has no powers of pardoning death sentence. He can only commute. Commute means changing the nature. If death penalty को change कर सकते हैं to let's say maybe from death penalty to rigorous imprisonment, or suspend कर सकती है for temporary time period, or remit कर सकते हैं, but he cannot pardon the death penalty, right? So the final mercy petition lies of against death penalty only with the President of India. So this makes the power of pardoning death penalty primarily given to the President of India. Then is court-martial cases. Again, there are many cases. Sometimes there are military laws. We have state law, we have union law. So there are military which are having their different laws, right? So in case any person is convicted against a military law, which is called as court-martial, only President has a power to pardon such sentences. Governor has no power to pardon sentences or conviction against any court-martial or any military law violation. Clear? So the Constitution has given the pardoning powers to reduce punishment in, of course, in cases arising from court-martial proceedings of military courts. Governor, he has no role in military justice. So again, it is ensuring that military discipline remains under the national and not state authority. Clear? Then the extent, again simply बताइए कि how President pardoning powers is applicable to central laws, military court offences, death penalty, special acts where clemency is constitutionally ensured. Governor has a more limited role of pardoning powers, which is focusing only on offences and laws enacted by the state legislatures. Again, governor's ka pardoning powers is less as compared to the president's pardoning powers, right? So in the end, we can mention that how exactly this clemency powers is just a basic corrective mechanism. So the governor's pardoning powers is narrower than the president's due to constitutional design. क्यों है? क्यों ज़्यादा इसको explain करना है conclusion में. Why? To preserve the national authority over death sentences, for promoting the idea of uniformity in military justice and central offences. Together, these powers ensure a balanced, humane justice system while maintaining India's federal and national security priorities. Clear? तो इस तरीके से थोड़ा balance conclusion लिखेंगे ना, so the examiner will get a sense कि this student has an understanding कि he is not just comparing the powers of president and governor on the fronts of pardoning powers, he is also explaining the reasoning behind of giving president more powers of pardoning as compared to that of governor. तो ये आप लिखोगे, that is going to give you extra 1-2 marks in the respective answer. Clear? So the next question is critically examine the increasing powers and role of Prime Minister and how does it impact other institutions in India. Technically, Indian context में of course है. So critical examine means you have to present both the sides, positives as well as negatives, right? So they are asking critically examine the increasing, but the question is establishing the fact that the powers of Prime Minister is increasing. The critically examine the increasing powers and role of Prime Minister, number one. And number two, the second part is how does it impact other institutions. Institutions matlab Prime Minister is under which institution? He is a part of executive, right? So now how it is going to impact the legislature, the judiciary, the executive itself, that is all asking a second part of the question. First part में हमें क्या बताना है कि how critically मतलब putting up both the perspectives, how the role of Prime Minister is increasing in the political functioning of the country, and number two, how that increasing role is affecting other institutions of the government of the state. Clear? Example, the executive, legislature and judiciary, right? So theme क्या है sir? इसमें पूरे hero कौन है? Hero is the Prime Minister. So again we can mention briefly about the role of Prime Minister, right? That is how you're going to introduce an answer. आप article number लिखिए, you can explain the essence of having a Prime Minister, what kind of position he's holding. That's how you're going to introduce an answer. In mention, the Prime Minister is what? हमने पढ़ा है द रियल एग्जीक्यूटिव, हु इज अ नॉमिनल एग्जीक्यूटिव, द प्रेसिडेंट इज अ नॉमिनल एग्जीक्यूटिव. सो प्राइम मिनिस्टर इज कॉल्ड एज अ रियल एग्जीक्यूटिव. ही इज द हेड ऑफ द गवर्नमेंट, right? So and again, which is the basic essence of parliamentary system, while the president remains the nominal executive. And over the time, यही है, यहाँ से आता है आपका examiner will get a touch sense कि now student after mentioning this is explaining that how the role of prime minister is increasing, because वही पूछा हुआ ना कि critical exam में increasing power, कि powers तो था but how gradually the powers are increasing, right? So over time, due to what? Many political and institutional factors, which of course we are going to discuss, the prime minister has emerged as a central axis of governance. Very important position, very powerful position, right? And scholars many times is describing India's system to be a prime ministerial government, not parliamentary form of government. इनको बोल रहे हैं what? Prime ministerial form of government, एक critics बोलती हैं, right, rather than the cabinet form of government. Clear? That's the basic essence you have established in the introduction of your answer. Now you are going to define that what are the reasons which are leading to increase role and powers of prime minister in the country. Now, number one, of course, he is the real executive because every decisions is taken on his behalf. He is the head of the government, right? So exactly basic बताने के लिए आपको प्राइम मिनिस्टर चूज कैसे होते हैं, मतलब let's say how he is being elected. If this is the legislature or Lok Sabha में 543 people enter. So and there are different political parties. Let's say this X political party has majority of seats. So now among them, and again of course there is Rajya Sabha also. So same political members will be there over here as well, same political party members. So prime minister can come either from Lok Sabha or from Rajya Sabha. दो options हैं, ठीक है? Prime minister यहाँ से भी आ सकते हैं और यहाँ से भी आ सकते हैं. Let's say the prime minister is chosen, right? So any political party who has a majority in the parliament, in the Lok Sabha, will form the government. So now technically they give a name of a person who is the head, who they consider is going to lead the government as the prime minister. He can either be from Lok Sabha or be from Rajya Sabha, but from the same political party. Clear? Now, can you become the PM? Yes, you can also become the PM. The only condition is what? Within 6 months, you have to get elected either to Lok Sabha or to the Rajya Sabha, right? वो movie देखी नायक एक दिन का PM, technically possible in the country, right? So the PM is now chosen, and then he decides his council of ministers, that is called as the cabinet, right? So इनके पास power है, he again can choose his council of ministers either from the Lok Sabha or from Rajya Sabha, from same political party, right? So basically he is heading the government, and इसी को बोलते हैं हम executive organ of the government. This is the legislature. So technically in India, the executive is coming from the legislature itself. Clear? Now, so the first point here is the real executive authority is lying with the prime minister itself. कि पूरे government को head करना, it is the responsibility of the prime minister itself. So he is the one who is driving major policy decisions, the entire administration of citizens, all decisions which are made by the council of ministers again is flowing through prime minister's leadership. Number one. Number two, control over council of ministers. So again, as I told, कि once prime minister is chosen, he decides who is going to be his council of ministers. So यहाँ क्या उनके पास discretion है, that is making him more powerful. So he decides, he has a power to choose his council of ministers, and there is no one who can question his decision. That is giving him more powerful. That council of ministers बन तो रहे हैं, अब सरकार को डिसीजंस देती है प्राइम मिनिस्टर along with council of ministers, but again council of ministers who are choosing this council of ministers, the prime minister itself. So that is how it is giving him more powerful situation. So PM recommends all ministers appointments to the president, then it's allocate जितने ministries होती हैं, किसको home ministry मिलेगा, किसको defense मिलेगा, किसको education मिलेगा, all of these decisions are taken by the prime minister itself. Ministers hold office only during the pleasure of the prime minister. Prime minister को power है, it can remove a particular council of ministers from his cabinet. And lastly, the resignation or a death, PM नहीं रहेंगे the entire government is going to fail. There is going to be fresh new elections in the country. So that is giving a supremacy of power to the prime minister's office. Then inner cabinet, basically essence ये है इस चीज का कि prime minister in spite of having his council of ministers, ये informal mechanism है, ये कहीं mentioned नहीं है हमारे constitution में, but he has his close group of people as well, right? So that is called as kitchen cabinet और बोल सकते हैं और inner cabinet कि prime minister is working, the executive organ consists of prime minister along with his council of ministers. Council of ministers contains different ministers, but again the prime minister is making a small group of people from this, which is called as inner cabinet, which is informal mechanism. इससे क्या हो रहा है कि now the major decisions are taken by this inner cabinet itself. Clear? So it ensures secrecy and speed, but it sidelines the formal cabinet, reducing what? The idea of collective responsibility of the government. The government is collectively responsible to Lok Sabha. बोलते हैं ना कि if the whether India is a parliamentary form of government, or how do we ensure this? That the executive is responsible to the legislature, right? So now executive consists of what? Prime minister along with council of ministers. But now prime minister is working with his inner cabinet. So is actually the council of ministers responsible to the Lok Sabha? No, sir. Only the inner cabinet is taking the decisions majorly, right? Just a understanding. Then we have प्राइम मिनिस्टर ऑफिस एज अ पावर सेंटर. ये और भी देखा गया है कि द पीएमओ ऑफिस व्हिच कंटेन्स मेजर पोर्टफोलियोज. So this is the one which is driving major policy decisions of the government, major flagship schemes of the government, programs and shaping policies, and it sometimes overshadows the cabinet decisions or cabinet secretariat as well, right? Enhancing what? The whole idea of bureaucratic centralization. Then again, party system and majority politics. Majority मतलब क्या है कि if let's say understand कि if a law is going to be passed, if a particular government is in majority understand in both the houses, in Lok Sabha as well as in Rajya Sabha, what are the chances under the leadership of a strong prime minister? If the prime minister is coming from a political party X who has a majority in Lok Sabha and who has also majority in Rajya Sabha, what are the chances of that bill going to be passed by the houses without any, let's say, questioning? Or very easily, because they have a clear majority in both Lok Sabha, Rajya Sabha, and the PM itself is very strong. So again, there could be chances of bill being passed in a non-democratic manner, right? The decisions and the counter arguments might get overshadowed by this majority government, but coalition government में इसकी possibility थोड़ी कम हो जाती है, right? So this, a strong majority Lok Sabha strengthens the PM's authority. Very good. The PM becomes unchallenged leader of the political party in parliament, and coalition eras earlier diluted this, but again majority governments are again what? Re-centralizing the powers. Then with this now the role of media also. Nowadays what we are seeing, media are portraying prime ministers as the supreme source of power. Again going by the idea of leadership presidentationalism, right? What means the PM's visibility in the media both at national and international level creates a quasi-presidential aura. Again, he is considered as, because the politics is now becoming leader-centric and it is enhancing PM's personal and mandate and charisma. So many times आप elections में जाते हो, you have two options. Either you vote for the person or you vote for the political party. So there are chances कि if we have a strong prime minister, so people in their voting behavior is not voting for the political party, not voting for the political person, but voting for the prime minister of the country. That is something which is again increasing the role of prime minister over here, right? Now इट्स इम्पैक्ट ऑन अदर इंस्टीट्यूशंस कैसे कर रहा है? यस, इम्पैक्ट ऑन प्रेसिडेंट। सर प्रेसिडेंट के पास पावर बचा ही नहीं है, ऐसे उसको रबर स्टैम्प बोलते हैं। अब पीएम इतना पावरफुल बन गया है, right? The prime minister nowadays is becoming so powerful with the idea of majority government that president has technically no decision. So president is basically acting on the aid and advice of council of ministers. PM is the prime source of communication between the cabinet and the president. So many a times important constitutional post, for example, appointment to the post of CAG, election commissioners, UPSC chairman, right? So it is being done by the prime minister itself. Why? Because it has become so much powerful. So this is what it is. क्या कैसे impact कर रहा है president की decisions को कि president is empowered to appoint the head of UPSC, the chairman of election commission, the CAG. But again, now prime minister is strong. He is aiding and advising the president of India, right? So that is again diluting the whole concept of the discretionary powers of president, except in rare political crisis. Then impact on legislature and cabinet. Again, मैंने बताया जितना strong cabinet है, high chances of bill getting passed bypassing the entire legislative process. So when ruling party has strong majority, parliamentary oversight is going to get weakened. Possibility of dictatorship of the cabinet, or more precisely we call it dictatorship of a prime minister. Inner cabinet is again being formed, जो overshadow कर रहा है the entire council of ministers, and the collective responsibility of the executive to the legislature just become very symbolic in nature. And there's a debate and deliberation in parliament decline as decisions are taken outside the legislative forums. कि वहां तो बस वोट करना है, मेजॉरिटी है हमारे पास, बिल पास हो जाएगा, right? That's how it is being happening. Then impact on judiciary. So nowadays, you understand, judiciary appointments are made independent from both executive and the legislature, right? But recently our honorable CGI has talked about the idea of revival of NJAC. उसका भी use कर सकते हैं इस answers में, right? So though judiciary is independent, but again government many times try to influence judiciary by what? Appointment processes. Number two, control over the resources, the amount of money, and the political criticisms of judicial activism in debating them in the parliament. That's how they are also controlling, or many times impacting the judicial framework as well. So judicial independence is of course a basic structure of the Indian constitution. So but with this strong prime minister leadership, strong let's say inner cabinet, there are chances of judiciary getting impacted by this as well, right? Now the impact on federal institutions. So nowadays prime minister, again the planning commission has been scrapped off. It is being constituted under the Niti Aayog, but Niti Aayog is headed by the prime minister itself. So again centralizing the intergovernmental relations, right? Enhances union's role in development, fiscal transfers and national policies. States may feel autonomy diluted due to when PMO drives major schemes and reforms. Then constitutional statutory bodies, again appointment of all of these bodies. There is a huge role of the government over here. Government, which is again headed by the prime minister itself. Election commission, CBI, CVC, Lokpal, right? So again, that is again leading to the idea that again perceptions of reduced autonomy of these institutions and the idea of politicization of these institutions, right? Now, as it was a question on critically examined, so some positive aspects we need to ensure in the answer as well. What are those? A strong PM is going to give a very clear and decisive leadership, maintaining political stability and a swift response to crisis situation. We have seen that as well. Useful in coalition eras or fragmented political landscapes. PM-led governments helps coordinate complex national programs. Example, GST rollout, disaster response, all of we have seen. But concentration of power has to be balanced because we have a doctrine of separation of power. We have doctrine of checks and balances which has to maintain. एक authority को इतना power बनाना is not a constitutional phenomena. So again, in conclusion, we are going to mention that again how balance has to be maintained in order to ensure the idea of separation of power, ensuring definitive checks and balances. So आपको बिल्कुल लिखना है में the rise of PM has a central figure in governance is strengthening the leadership and policy coherence but creates risk of executive overreach. right? A healthy democracy requires that PM's authority be balanced by what? A vigilant parliament, a functional cabinet system, independent constitutional bodies, and an assertive judiciary. So sustaining India's democratic equilibrium demands that the growing prime minister's centric governance does not erode institutional autonomy. That is the basic idea. इस तरीके से आप conclude कर सकते हैं in a balanced way forward. Clear? The next question is, how does the federal structure in India accommodate the diverse needs and aspirations of different states? Number one, again, going by the idea of chapters, India has some of the features of the constitution which are the federal features of the constitution. So technically, just to make you understand this, the entire system of government in the country, government cannot function alone. So it was decided, let's divide the powers of government at two levels. One is at union level and one is at the state level. So this idea of division of power at two levels is called as federalism. But we have discussed, and again, how are powers demarcated in schedule 7 of the constitution. We have three lists, that is union list, state list, and concurrent list, on which matters the union government can make a law, on what matters the state government can make a law, and in this both can make a law on the concurrent list matter. So again, the powers are defined, the subjects of governance are defined, right? So, but it is also being told that again we have a strong tendency towards unitary government, or we have a unitary biasness in the constitution. So, but the question here asks a different aspect. How we are ensuring that again the federal structure in India accommodates what? The diverse needs and aspirations of different states. So how we are maintaining this, how we are maintaining what federal principles of the constitution are maintaining, that the aspirations of the state is also going to be met in the constitution. We are going to mention number one, are there any challenges to them? Number two, and number three, how are they addressed? If there are any challenges to the federal principles functioning of the constitution, then how these challenges are being addressed. So question has three parts. Clear? Just a second. So now, what is the theme of the question? Thumb rule hero. If you look at the question, what is the theme? Theme here is the federalism or the federal structure. So you're going to briefly define what do you understand by federalism? How is the federal structure of the Indian constitution defined? That is going to be the introduction of your answer. So again, anything around this particular theme, you can write down in introduction of your answer. Again, re-emphasizing the fact, there is no one way to introduce an answer. You need to identify the theme first, and then around that theme, you can write the introduction of your answer. Either be it definition, either be some contextual understanding of, either be some current example, either be any relevant constitutional articles, anything you can mention in the introduction of your answer, right? So कभी भी डरिए मत कि introduction में एक ही introduction हो सकता है, नहीं, there are different ways to introduce an answer. Clear? So introduction में ये बताना है कि how India's federal structure is its unique, where again we have India में क्या गया? India is defined as what? Union of states with what? Strong centralizing tendency, but yet flexible. ऐसा नहीं constitution is completely rigid. It is flexible. It is accommodating the needs of the state as well, right? Which has a very, because India is a very large, we have a diversity in the country, diversity on different parameters of culture, religion, caste, right? All of these are accommodated in the constitution of the Constitution of India. So it is flexible enough to accommodate vast regional, cultural and socio-economic diversity through constitutional design, institutional mechanisms and asymmetric federal features. So asymmetric means क्या? हमने सारे countries, सारे states को हम एक समान नहीं देख रहे हैं. There is some areas where again we are giving some special status to some states on some special considerations as well. That is an idea of asymmetric federalism. So that is maintaining, balancing what? The idea of unity with diversity in the country. So ऐसे terms को लिखिए अपने answers में. The whole idea of unity in diversity, the whole idea of asymmetric federalism. These all keywords, if you are writing down in your answer, it is going to give a good impression to the examiner who is evaluating copy, that again the students has a very nuanced understanding of the topic. Clear? Now, the first part क्या पूछता है? How does the federal structure in India accommodates diverse needs and aspirations? So basically, we are going to mention that how and what are the federal features of the Indian Constitution, which is maintaining the idea of federalism. So again, very simple. आपने बहुत पढ़ा होगा इसको. So division of powers. Again, we have discussed कि how the entire government is, let's say, how 7th schedule contains the division of powers. Union list contains matters of governance which is to be done by central government. State list contains matters of governance to be done by the respective state government. And we have concurrent list as well, on which both can make it. So again, there's a clear demarcation of laws so that there is no ambiguity on which matter I can make a law and which matter the state government can make a law. Clear? And in fact, if you look at the subjects, all subjects which require uniformity of lawmaking throughout the country are kept in the union list. Some subjects which requires state-specific legislation, for example, agriculture, state subject. Why? Logic kya hai uska? Because every state has different soil type, different climatic conditions. So again, one law which is of agriculture for entire country won't be suitable, which have different geographical locations, climate, and different types of soil. That is why it is kept in state list. So again, such topics of governance which do not require uniformity of lawmaking throughout the country are kept in state list. Similarly, again, subjects in concurrent list are again kept in the consideration that again, sometimes there are need on certain matters where again uniformity is required. For example, we can talk about education is currently in the concurrent list, right? That's how you can understand the utility of subjects. So again, this has for the federal principle maintaining federalism. So clear demarcation of powers have been given to the respective state government, and it is constitutionally mandated through 7th schedule of the Indian Constitution. Clear? So ये पहले लिखोगे आप उसमें कौन subjects है example तो लिख लो, right? Then for the better federalism, we have now a third organ of government, that is the Panchayati Raj institutions and municipalities. That is the idea of local governance. So again, we are more decentralizing the powers. So more powers are being given to local people. So again, going by the idea of how more autonomy are being given to the respective states, not at state level, we are more decentralizing even at the local level with the coming up of 73rd and 74th Amendment Act. So it is empowering Panchayati Raj institutions and local bodies, enabling the ideas of local planning, implementation of welfare schemes at a very local level. So enhancing the democratic participation. You will accept point. Then the third is asymmetric federalism. What is asymmetric federalism? Ki we are not considering all states equal. Some special status have been given to some special states. Some special provisions are in the constitution which are respecting some cultural regional diversity of certain special states, which are mentioned in part 21 of the constitution. Again, you can talk about here is to meet unique historical, cultural and geographical needs. Special provisions for 12 states have been made, including Nagaland, Mizoram, Assam, Jammu Kashmir, Karnataka. These provisions are protecting what? The local customs, tribal identity. Examples dikhiye. We have also what? 6 schedule areas, 7 special developmental boards. For example, 6 schedule contains the autonomous districts and regional councils are set up in Assam, Meghalaya, Tripura and Mizoram. They have powers of their own land reforms, taxation, forest, social customs and land taxation. Again, special bodies are being, boards are being constituted, which is requiring a certain, going with the idea of what? Asymmetric federalism. Okay? Now, the whole idea of cooperative mechanisms and intergovernmental coordination. So again, we have an idea of cooperative federalism, where again, we are coming together through this idea of cooperative federalism. The whole idea of coming up Niti Aayog is again an example of, classic example of cooperative federalism. One classic example is implementation of GST. Sir, GST में हुआ क्या? States have given up their powers of taxation to central government. again a classic example of how states have cooperated in the developmental process of the country with the implementation of GST and giving up their powers of taxation, right? So example with this, we have different forums which are maintaining federal balance in the country. We have Niti Aayog, which has representation both from central and state governments. We have zonal councils, we have interstate councils to promote the idea of negotiation, consultation, policy coordination. So it is enabling states to voice their concerns and influence the national policies, right? Now, we are addressing the second part कि हमें देख लिया कि how through different provisions of the constitution it is maintaining the idea of what India is accommodating the diverse needs and aspirations of different states. ठीक है? Now the second question, are there any challenges to this? And if challenges, how are they addressed? So again, इसमें आप बिल्कुल comparative में भी बना सकते हैं कि challenges and then how it is addressed, because the 12 marker है. So again, you need to stick to 200 words word limit as well. So the first thing is, challenge area is what? Our constitution is also being biased towards the central government. We know this. We know this that we have a strong tendency which is favoring the union government, right? So that is again a challenge कि the residuary powers क्या होते हैं कि मान लीजिए हमने बताया ना 3 लिस्ट है. Schedule 7 contains 3 lists: union list, state list and concurrent list. So this list was made in the year 1950 when we enforced the constitution. Sir, 1950 में did we had drones? 1950 में did we had cryptocurrencies? 1950 में did we had artificial intelligence? But now we have this. Sir, now these subjects were not there in the year 1950, but now they are. So who will make law on such subjects? So again, for that we have a separate list called as residuary list. So the new matters or the new subjects of governance which are emerging in the country are kept in residuary list, and the central government has an exclusive power to make laws in the residuary list subjects, right? So residuary powers is lying with center. Governor is appointed by center who is working in the state government, right? So states are demanding more autonomy. आप देखोगे ना nowadays with this whole idea of multiple things जो आपने देखा होगा न्यूज़ में थे, I can think about is the whole idea of governors passing of bills and reserving the bills for presidential reconsideration, the whole idea of implementation of 3-language formula, which saw a lot of maybe considering them as maybe diluting the whole idea of federalism, the whole idea of we talk about the fiscal federalism. All of them states are demanding more autonomy कि हमें सर more powers चाहिए. That is major challenge. ठीक है? So how it is being addressed? कैसे एड्रेस करें? We have made interstate councils which are going to address all such issues between the center and the state government through this particular council. So again, through coordination and dialogue, this is being maintained. So again, the problem, the challenge, and how it is being addressed. Number 2 problem is misuse of emergency power. So many times you understand, as governor is appointed by the central government, right? So he is the one who is going to inform the central government that this is the right time or the time has arisen when there is a need for implementation of president's rules. Many times you understand we have multi-party system. Many times you understand कि central government में different political party है, state में different political party है. Sometimes due to political considerations, president rule or this whole idea of imposition of emergency in the states are misused in a political manner, right? So historically used to dismiss state governments for political reasons. So again, SI Bomai case mein in 1994 it was made clear that it is not beyond judicial review. The intent of let's say imposition of president's rule is again questioned in the court of law, and it should be the last resort, not the first thing to do if there is any disturbance in the state. So again, Supreme Court intervene karke this issue has been addressed. Then we have fiscal imbalance. Many times you understand nowadays, अभी भी news में आते हैं आप देखते हो कि how states have been demanding more fiscal autonomy. With this whole scrapping of GST compensation cess हट गया इस साल. So now states are telling we have less powers or less funds of our own, right? And the devolution which is being done is also less. So technically state government told ki we are having less amount of financial autonomy, right? So states depended on central and grants and tax transfers, limited revenue sources. Finance commission create kiya gaya, which is again going to make sure that out of all pool of tax which is being collected, on what basis, on different criterias, how it is going to be distributed between different states. Okay? So again, that is how it is being done. Then we have interstate disputes. Again, nowadays you understand there are many times disputes arising within states also. The whole idea of Kaveri water dispute. Again, for that matters, what we have done, we have created interstate dispute. We have Article 262, which is enabling Parliament to set up tribunals for setting up of interstate disputes for conflicts over river waters, boundaries, and resource sharing. Then पॉलिटिकल एंड एडमिनिस्ट्रेटिव फ्रिक्शंस, अगेन डिफरेंट, ये सबसे बड़ा प्रॉब्लम है आज की डेट में कि डिफरेंट पॉलिटिकल पार्टी एट द स्टेट एंड द सेंट्रल गवर्नमेंट इज creating a kind of friction between the in the functioning of a federal setup of the country, right? So for that, what we have done, we have created Niti Aayog, where again both parties have got a representation and a say in the process of planning and development, right? So now we can mention and how conclusion is there, that again although India is having federalism, but again the federalism making sure that again it is flexible. Of course, we can make changes to the constitution through amendment process. We have an idea of cooperative federalism. We have an idea of asymmetry, which is again giving some special status, some special states on the basis of their needs and demands to enable to absorb regional diversity while maintaining national unity. Tools such as special provisions. We have the idea of decentralization, tribunals, finance commission, judicial oversight ensure that tensions are managed in a constructive manner. The Indian model thus represents a pragmatic balance, promoting what? National integrity. सबसे important चीज है national integrity while recognizing legitimacy of regional aspirations. Again, conclusion में इस तरीके से balanced way में लिख सकते हैं. Clear? The next question is mention 3 demerits of judicial activism. Again, वेरी क्लियर क्वेश्चन, कुछ नहीं करना है, सिर्फ 3 डीमेरिट्स लिखनी है जुडिशियल एक्टिविज्म की. सर थीम क्या है? व्हाट इज द हीरो ओवर हियर? द थीम इज व्हाट? जुडिशियल एक्टिविज्म. सो व्हाट वुड बी द इंट्रोडक्शन टू द आंसर? यू कैन डिफाइन व्हाट यू अंडरस्टैंड बाय जुडिशियल एक्टिविज्म. यू कैन मेंशन, इफ अगर बोल रहे हैं डीमेरिट्स में, तो आप डीमेरिट्स के अराउंड भी स्टार्ट कर सकते हैं अपना इंट्रोडक्शन. सो अगेन either way, or either defining judicial activism or defining it in the context of how it is leading to judicial overreach can also be as can also written as the introduction to the answer. Clear? So here judicial activism basically means what? अब judiciary का काम है कि to give justice, right? So sometimes what judiciary does is it takes up matter in out of everywhere to its own hand and give decisions on such matter. For example, very recently Supreme Court ने बोल दिया कि in Delhi NCR stray dogs should be kept out. They have to be not there in the city. Suo moto case. Supreme Court ने बोल दिया सर दिवाली में we can burst green firecrackers for 2 days. Again, judicial activism. So there are many a times judiciary is taking up certain suo moto cases and giving judgment on their behalf. So पूछा गया है in question the answer question कि सर इस judicial activism का क्या 3 demerits है? Clear? Very simple, very clear forward, but in the demerit part you need to explain them through some examples and some recent examples also. Clear? So judicial activism is playing a vital role in protecting the rights. अच्छा भी है ये, ensuring accountable governance. Sometimes executive and legislature अपना काम नहीं कर रही है तभी judicial activism हो रहा है. This is also a reason, right? So yet its expansion is also raises several concerns about constitutional balance, institutional competence, and demographic legitimacy. Clear? So that's how we are going to start. Very clearly you're going to mention the 3 demerits of judicial activism, number 1, number 2, and number 3, nothing beyond this, and again explain them with examples. So number 1 is usurpation of legislative and executive power. Sir, judiciary activism से क्या हो रहा है कि judiciary is taking up the task of executive and legislature. Sometimes laws have to be made by the legislature, implementation part has to be done by the executive. So ये काम जो executive legislature का है, ये judiciary अपने हाथ में ले रही है through what? Judicial activism. That is how it is usurpating the powers of executive and legislation. So they are through judicial activism, Judiciary is entering into the domain of lawmaking. Judiciary is entering into the domain of policy implementation as well, right? So when courts are guiding or giving guidelines or directing certain schemes, prescribing administrative procedure, they may undermine democratic accountability because judges are unelected, sir. जो लॉ मेकिंग काम है, in democracy, we have elected our representatives. We have chosen them to make law for us. If judiciary is making law for the country who is an unelected body, it is undermining the whole idea of democracy itself. Then it is also creating the idea of judicial overreach. Sir, आप अपने काम से many times judicial activism is correct, but again sometimes judiciary is overreaching its power. That is called as judicial overreach. ठीक है, so that's how it is turning judiciary into judicial governance. कि governance का काम सर सरकार का है, executive and legislative organ का है, आपका काम है सिर्फ justice देना, but you are also entering into the domain of providing governance. So that is how it is. Examples, sir, you also understand, very important, the Vishaka guidelines कि Supreme Court has given us extensive guidelines on sexual harassment at workplaces. ये जरूरी भी था उस टाइम पे. An example which was necessary also, कि there was no law which was prescribing any kind of punishment with respect to sexual violence at workplace. So this is something but judiciary passed a guideline through a case which was filed over here. ये guidelines हमें follow करनी, which are guidelines that led to again making up of a law by the government. But many times, while progressive in nature, critics many times argue that it is crafting very detailed regulatory framework is a legislative function. Parliament later replaced with the 2020 Act. ये हो गया, but again काम था legislature का, but किया judiciary ने. Again example of judicial activism. Then you understand, law making is an expertise. We have different ministries, we have secretaries working under different ministries who have expertise in that particular field. Judiciary has no expertise in technical matters. So sometimes expertise is lacking while you are giving maybe different kind of judgments. I'll take you through an example. So judges are experts in law, but they are not expert in different specific domains of law making. For example, technical domain पे कोई knowledge नहीं है, environmental domain पे knowledge नहीं है, in let's say of course they have knowledge, but they do not have an expertise over scientific matters, economic matters, let's say technical matters, or you can talk about any other policy decision matters, right? So judicial directives which are given through judicial activism, many times it may sound impractical. ठीक है, so this is risk of creating what ineffective or unimplementable policies. For example, sir उन्होंने बोल दिया recently, very recent example, कि Supreme Court allowed bursting of firecrackers in Delhi for 2 days, right? And the firecrackers were green. But again, we have seen, sir, in last 10 years, how severe the condition of Delhi becomes, specifically during the months of October to February. We understood this. We understand the sentimental value of celebrating the festival of Deepavali. But at the very same time, we need to ensure that the people of Delhi are getting clean environment. Green firecrackers are allowed, but again, were people bursting green firecrackers? So that has to be taken up into consideration. कि आप environmental domain से you did not thought upon, you just gave opinion on the matters, looking up like only bursting firecrackers. You did not understand the problems it might face in implementation of that particular directive, right? For example, बोल दिया गया है कि diesel cars are banned in Delhi which are more than 10 years, right? Mining operations पे you are giving judgments. So again, you do not have expertise on these matters, right? So these are criticized many times because they have very limited idea and they are passing these directives which is actually facing problem in terms of its implementation. I mean, examples देख चुके हैं, right? Then we have the third is again because for instance, the blanket ban on diesel vehicles over 10 years in Delhi was questioned for lacking holistic environmental modeling and failing to account for economic displacement of transport workers, right? अब आपने तो बोल दिया कि diesel ban, but many workers who are coming or commuting, or the workers who are traveling in these diesel vehicles, how can they commute to the workplace? What about their social security? What about their daily wages, what they're earning, right? So such matters which require an expertise, which requires a detailed deliberation, is not being done through the process of judicial activism. That is second demerit. Third is increased workload and potential erosion of judicial authority. Sir, judiciary itself is overburdened. We have a lot of cases pending in court. So if you are making new decisions, new policy directives, new law implementation directives, so now you are technically not resolving the pendency, but again doing task of judicial activism. और technically बहुत time ये भी देखा गया कि sometimes the laws or the directives are sometimes very impractical to implement. So technically फिर judiciary पे जो the in fact to understand, out of 3 organs of the government, judiciary is the one who has some kind of supremacy, because that organ is called as a protector of Indian constitution, protector of people's rights. But if decisions or on the name of activism which are being given by judiciary, if it is sometime very impractical, people would lose this whole idea of trust and the respect which they have for that particular organ. So again, the dilution of respect might come up. So that is one reason that again you have, it is again increasing the burden of cases, number one, right? And again, they are also, there is also legitimation fears. When executive delays or ignores judicial directives, the authority of judiciary may appear weakened before the public. कि sir, activism में सरकार ने, judiciary ने बोला कि executive you do this thing, but again executive is not implementing that. So again, it is eroding the trust of people over judiciary. Example, despite repeated judicial orders of cleaning Yamuna water and improving the river ecology, administrative agencies have failed to comply them effectively, right? Continuous non-compliance highlighted the judiciary's limited enforcement capacity. कि enforce तो नहीं कर पा रहे हो, आप लोगों ने सिर्फ बोल दिया कि you need to clean Yamuna, but again due to administrative challenges, of course, it is not being cleaned. So raising concerns that expansive judicial orders may lose moral and institutional force when not implemented. So in conclusion, we can mention that again how a balance has to be maintained. Judicial activism is right, but it should not overpower. It should maintain the idea of checks and balances. That is the basic idea you need to mention over here. Basic है, कुछ भी आप लिख सकते हैं इसमें. Maintaining the idea of separation of power, at the very same time ensuring checks and balances. So judicial activism is essential for right protection and democratic deepening, especially when other organs fail to act. However, its excesses risk upsetting institutional equilibrium, creating implementation gaps, undermining judicial legitimacy. A balanced, restrained approach anchored in constitutional boundaries and technical consultation ensures harmony between judiciary, legislature and executive. That's how you're going to conclude down the answer. Clear? The last question for the day. What alternative mechanisms of dispute resolution have emerged in recent years? Sir, what is the meaning of alternate dispute resolution mechanism? So what is the traditional way of dispute resolution, sir? Whenever I have any dispute or any matter, where do I go? I go to court. That is the idea. So, but now in the recent years, there are different other institutions which have came out, which are considered as alternate dispute resolution mechanisms. So we are going to mention that. आप देखते हो ना, लोक अदालत, ग्राम न्यायालय, all of these are alternative dispute resolution mechanism. क्या कोर्ट नहीं जा रहे हैं, अपने केसेस को यहाँ पे लाके you are maybe getting that case resolved with these kind of institutions coming into picture. So we are going to mention over them, what are those, how they have emerged, and second, how far they have been effective in its implementation, right? So you understand what would be the need. Hero क्या है सर इसमें? Alternative dispute resolution mechanism. So we are going to define what do you understand by alternative dispute resolution mechanisms. We can mention that again, what was its need of creation, क्यों जरूरत थी इसकी. So if I ask you simple questions, what is one problem which the judiciary of the country is facing? What would you tell? क्या problem in judiciary country में? So number one problem is, in fact, last month we had this whole report. कि judiciary in India has all-time high pendency of cases, right? So we have this one proverb: justice delayed is justice denied, right? So with this into coming with this idea in the country, with a huge pendency of cases, justice delayed being justice denied, so there was a need for creation of alternative dispute resolution mechanisms, which is going to solve the disputes in a speedy manner. So that is where it led to creation of alternative dispute resolution mechanisms. इसी के अराउंड आप लिखोगे अपना introduction, right? For example, here alternative dispute resolution mechanisms have expanded rapidly in India to address what? The challenges of overburdened courts, high litigation cost, procedural delays, and lack of access. All of these are the problems of current judiciary. That is what was needed for the creation of this alternative dispute resolution mechanisms, right? So they, what is the aim for this? They are making it what? Speedy, cost effective, consensual and flexible models of resolving disputes out of what? Court नहीं जाना है, traditional court नहीं जाना, court के बाहर ही you are settling your dispute. That is our main aim of these alternative dispute resolution mechanisms. Clear? This is something you're going to write down in the introductions of your answer. Clear? Now we are going to address that what are the emerging forms of alternative dispute resolution mechanisms in the country. So number one is Lok Adalats. We have seen under this Legal Service Authority Act, that is the creation of free legal aid. Lok Adalats have been set up under this, and they are resolving any pending or pre-litigation disputes. Matlab, what is pre-litigation? Before going to judiciary, if there are any family disputes, if there are any motor accident claims, if any bank recovery, any compoundable offences, they can go to Lok Adalats. Lok Adalats are being set up time and again, right? And all of these disputes, before litigating into the court, it can get a resolution from Lok Adalats. Clear? Right? So it is known for very speedy, informal and consent based. Both parties की बातें सुनती हैं, कोशिश किया जाता है कि through mediation that dispute can be solved. So that is one of the alternative dispute mechanism is what? Lok Adalats. Second is family courts. So they have been set up under the Family Courts Act of 1984 for matrimonial and family disputes. So again, many times you understand we have a lot of problems of divorce cases, and again sometimes if they are not maybe addressed at a defined point, let's say time period, it can lead to a lot of problems of both parties, right? So for that we have special courts which are called as family courts. So again, they are again giving counseling facilities. They are asking them for conciliation, counseling over adversarial litigation. And again, it is ensuring sensitive, specialized handling of family matters, because the judges over there are sensitively handling such cases, giving them proper counseling, and again explaining them that how they can go for this whole process without going to the court. Then we have Gram Nyayalayas, which are set up at a very grassroots level through Gram Nyayalaya Act of 2008 at a very village level, where again, because many people living in rural areas do not have an access to justice. They don't have, in fact, the knowledge or the money to go to courts and fight their cases. So for that, Gram Nyayalayas are set up at a very local level or village level. So they are intended to bring justice to rural areas with simplified procedures and in local language use. It is promoting accessibility and community-based resolution. Then we have Mediation Act of 2023. It is the very first comprehensive law institutionalizing mediation in India. Mediation means what? कि दोनों पार्टी को बैठाओ और find a middle path or a path of resolution without going to the court. So again, mandatory pre-litigation mediation is there. Enforceable mediation settlement agreements are there. Online mediation recognition are also being done. So it is strengthening structured mediation beyond court annexed models, right? So then we have institutional arbitration. So now people are moving, shifting from ad hoc to institutional arbitration. कि अब ऐसा नहीं है कि arbitration के लिए you need to only, there are institutions which are specifically set up for doing the task of arbitration. What is arbitration? Maybe both parties come up, they discuss, both lawyers come up, they discuss, and they resolve or they discuss the matter out of court settlement जो बोलते हैं उसको हम, right? So institutions like India International Arbitration Center, MCIA, they promote professional arbitration with timetables, rules and trained arbitrators, aligns with India global commercial dispute resolution standards, right? Then we have also online dispute resolution mechanism, where again technology driven platforms are there, where again e-filing, virtual hearings and automated workflows are being done, right? And they're widely used specifically for financial disputes, e-commerce grievances, MSME payments, and they're ensuring remote, scalable and efficient disputes. इसमें आपका आइडिया ये है कि जितने भी आपको 5-6 प्रकार के all 5-6 types of ADR you are knowing, you're going to mention them, you're going to mention what is their purpose, through which act they are created, and what kind of cases they are solving, and how they are leading to effectiveness of justice delivery in the country. यही 4 parameters में आपको इन 5 institutions के बारे में लिखना है. Clear? Now effectiveness बताना है किस तरीके से? This is where you need to give some datas. कि we have discussed कि we have ADRs, but how effective they are? Sir, एक problem which I come across is कि these decisions again can be challenged in the court of law. If parties, again ये है कि many times parties agree to decisions, but again there is also a instance if any party is not agreeing to the decision of these ADRs, they can go and file a case in the court, right? So that is a basic demerit. Okay, so speed and efficiency, of course, the timelines have increased, the speed justice has increased with this coming of ADRs. Mediation and ODRs, online dispute resolution, significantly has reduced time taken for dispute settlement. Then we have cost effectiveness. Many times lok adalats are very cheap, no cost. Mediation and lok adalats minimize procedural cost, because sometimes you're not going to hire any lawyer, no high cost of going to the court, right? So ODR reduces travel and documentation expenses. Confidentiality in arbitration and mediation protects business relationships. Then reduce case backlog. Of course, जितने cases ADR solve होंगे उतना pendency कम होगा judiciary का, right? So national लोक अदालत settle lakhs of cases on a single day basis, drastically reducing pendency in judiciary. Pre-litigation mediation prevents cases from even reaching the court itself. Court जाने के पहले ही they are through mediation process they are settling that particular case. Then party autonomy and relationships resolution. Parties choose neutral procedure and outcomes, more collaborative than adversarial, leading to high settlement compliance. Then 3 is persistent challenges kya hai? In spite of the successes, what are the challenges? That is the third part of the question. Kya challenges are? Judicial intervention in arbitration, right? So excessive court interferences in the awards given by the arbitration is making the arbitration almost as slow as the litigation process. Ki arbitration ke jo hai na, it is taking a lot of time, which is again into delay in the arbitration process. Then we have low awareness and weak rule infrastructure. People are less aware of these alternative dispute resolution mechanisms, and they still prefer going to the court because of lack of awareness, right? So many citizens remain unaware of the mediation and arbitration benefits. Gram Nyayalayas underperform due to staffing shortages and inadequate infrastructure. Then enforceability challenges. The arbitration awards, though binding, are frequently challenged again. They can be challenged again in a court of law, again delaying the final resolution. Then again, quality and cost issues. Again, you have made ADR, but the quality of judgment sometimes are questioned, right? So lack of accreditation of norms lead to uneven quality among mediators and arbitrators. High fees by senior arbitrators undermine the ADR's whole idea of making, which was considered to be a cheap way of, or an affordable way of justice delivery, right? So in conclusion, we can mention that again how it has been a very effective way of justice delivery, right? But now we need to make sure that the challenges what we have discussed, any challenges ko aapko likhna hai ki what are the challenges and how they can be addressed to ensure the effective functioning of the noble ADR in the country, right? So ADR mechanisms, they are strengthened by, again, Act aa gaya hai, Mediation Act. Institutional arbitration and digital platforms are increasingly becoming an essential component of India's justice delivery. While effective in reducing pendency and in providing speedy justice, cost-effective justice, their full potential can only be realized by better infrastructure, public awareness, and minimized judicial interference. That's how you can conclude the answer, right? So with this, we come to an end of discussion of today's 2023. I think one question is left from 2023, and the next class we're going to discuss that one question plus the questions of 2024 mains examination. Understand this fact. It is very important to analyze previous year question papers of mains. It's giving us a hint to what kind of questions you can expect in this particular year, right? Look at the themes, start practicing. Just don't listen to the discussions. Analyze how you are going to write an answer. देखो content सबके पास है, everyone has a content, but the idea is how beautifully you are writing that content in the form of answer writing, addressing the demand of the question, adhering to the word limit, and at the very same time giving a good presentation and making sure that the examiner is attracted while reading your answers. That is a task. This is only going to come up if you start practicing answer writing. So again, of course, VisioIAS is providing you UPPCS Mains answer writing test series. Please enroll that test series. That is going to help and make sure that again you are well prepared with good answer writing practice before your actual examination. Clear? So keep on revising, keep on reading. We'll meet tomorrow with the next set of questions. All the very best.